hostess for Study for the Bar in Your Car, the podcast where you can study for the bar in your car. You can email me at podcast@studyforthebarinyourcar.com. Or if you are an attorney or know an attorney who needs some legal work done, they can email me at hello@legalwriterandlawclerk.com. All right, so today we're going to try something new. Now, I know we're all wrapped up with civil procedure and we had our quote unquote last episode, but this is a bonus episode because I want to try something new and maybe it'll fail, but maybe it'll work, right? So I'm heavily into technology. Anyone who knows me knows I am heavily into technology. In fact, before I went into law, I was working in technology in various positions. So I want to use some of my technical skills to help study for the bar exam. So here's what I've done. I've taken a bunch of the NCBE MEE Civil Procedure questions, like, I don't know, maybe 15 of these questions. I've put them into AI and I've asked AI to analyze these questions and to come up with totally new, original, totally different questions or fact patterns based on the style of these NCBE questions, and then to give me those questions. So I've asked for 3 questions, and let's try going over the first one to see, if it's any good. So what I'm going to do is I am going to read the question, and once I read it, I am going to then go away and try and figure it out myself. But who will come up next are my AI buddies, Maud and Claude, or, whatever we've named them. And they're going to dissect this question because, I'm not an attorney. I'm a law student like you. I don't have all the answers, but maybe this AI can develop the answers. So when I asked for the AI to write the question for me, I also asked it to develop the model answer based very similarly on how model answers are developed for the NCBE questions. So we have a question and answer. Does it make sense? I don't know. We'll find out. So I'm going to read you this question. This first one is on subject matter jurisdiction. And then I'll send it off to my AI friends. And then I'll come back to you in the end and we'll see if we've learned anything together. All right. So this is fact pattern 1. It's on subject matter jurisdiction. And, when you get to the bar exam, the questions aren't labeled. You won't get to the question and it won't say, this is subject matter jurisdiction, or this is contracts, or this is civ pro, or this is torts. It's just a question and you have to sort of figure out what it is. So we are at a little bit of an advantage that we know what is going to be in this question. All right, so facts. Paula, a lifelong resident of State Alpha, decided to pursue a new career opportunity in State Beta. On January 15th, 2023, she accepted a job offer in State Beta. She signed a 1-year lease for an apartment starting March 1st, 2023, and informed her State Alpha landlord that she would be vacating her apartment on February 28th, 2023. She moved her essential belongings to State Beta on March 1st, 2023. She started her new job on March 5th, 2023, and obtained a State Beta driver's license on March 10, 2023. She kept her State Alpha bank accounts open and returned to State Alpha for a week in April 2023 to finalize selling her State Alpha house, which she had owned for 10 years. She intends to see how her job in State Beta goes before deciding if the move is permanent. But for now, she considers State Beta her home. On May 1st, 2023, while driving in State Alpha, Paula was involved in a car accident with David, a citizen of State Alpha. Paula suffered injuries, and her car, valued at $30,000, was totaled. Paula incurred $50,000 in medical expenses. On June 1st, 2023, Paula filed a lawsuit in the Federal District Court for the District of State Alpha against David. Her complaint alleged negligence and sought $30,000 for property damage to her car and $50,000 for her medical expenses. In the same lawsuit, Paula also sued Car Corp, the manufacturer of her car. Car Corp is incorporated in the state Gamma, is incorporated in state Gamma, and has its headquarters and all manufacturing facilities in state Gamma. However, Car Corp's CEO and executive team, who make all major corporate decisions, operate exclusively from a small administrative office in state Alpha. Paula added a claim against Car Corp in her federal lawsuit alleging a design defect in her car's airbags and that this defect contributed to her injuries. She is seeking an additional $70,000 from Car Corp. David filed a motion to dismiss Paula's entire action for lack of subject matter jurisdiction. Car Corp also filed a motion to dismiss the claim for lack of subject matter jurisdiction. Questions. How should the court rule on David's motion to dismiss Paula's claims against him for lack of subject matter jurisdiction? Explain. 2. How should the court rule on Car Corp's motion to dismiss Paula's claim against it for lack of subject matter jurisdiction? Explain. Okay, so now we've got this fact pattern. This is totally typical of what you find on the bar exam, these sort of questions. And when I see all these dates, my mind goes, ay, 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 so much to go through. But take it one date at a time. I suggest you take this question away and work on it. And I will see if I can upload this to my website so you can download it as well. And then try working on it and then listen to the answer. So now I'm going to hand it over to our AI friends who are going to provide the answer. And I will also come back and I will read, because I don't think it's going to read the model answer that I have. So we'll come back in just a bit. I'll read the model answer and then I'll hand it over to my AI friends.
This is a bonus episode of Study for the Bar in Your Car. Thanks, Angela.
Yeah, thanks, Angela. We know you're working hard.
Absolutely. And every minute counts for bar prep, so we're jumping right into a key area using some great points from Angela's notes.
Exactly. Her outline sets up a classic bar exam hypothetical. We've got Paula, lifelong resident of State Alpha, suing David and Car Corp.
Okay. And they've both filed motions to dismiss, arguing the court doesn't have subject matter jurisdiction.
That's the core issue. So our mission today is to break down how a federal court would likely rule on David's motion and then on Car Corp's motion. Really unpack the rules and apply them here.
Perfect. So let's start with the basics. Subject matter jurisdiction. It sounds technical, but what's the big idea?
It's fundamental, really. It's about whether the court has the power to even hear this type of case. You know, not every court can hear every dispute.
Right. And federal courts, they're courts of limited jurisdiction, aren't they? They can't just take any case that walks in the door.
Precisely. Their power is generally limited to two main buckets. Cases involving a federal question, like a federal law, or cases based on diversity of citizenship.
And looking at Angela's notes, with the focus on Paula being from State Alpha and these other parties, it feels like we're heading towards diversity jurisdiction.
That's the strong suggestion, yes. It's a very common basis tested on the bar exam. It usually involves figuring out where everyone is from for legal purposes.
So what does it take? What are the ingredients for diversity jurisdiction?
Okay, so the main statute, 28 U.S.C. Section 1332A, lays it out. Basically, it covers suits between citizens of different U.S. states.
Okay, different states. Paula from Alpha, David maybe from Beta?
Exactly. Or it could be between a citizen of a U.S. state, like Paula, and a citizen or subject of a foreign country.
So international cases too.
Yes. And there's a crucial second piece, the amount in controversy. The claim has to be for more than $75,000, exceeding $75K.
Got it. Different states or U.S. versus foreign citizen and over 75 grand. Now, Angela's notes also mention complete diversity. That sounds important.
It's critical. Complete diversity is a strict requirement. It means every plaintiff must be from a different state than every defendant.
Okay, so no overlap at all. If Paula is from Alpha, none of the defendants can be from Alpha.
Exactly right. No plaintiff can share state citizenship with any defendant. Think of it like team plaintiff versus team defendant. They can't have anyone playing for both sides, citizenship-wise.
That makes sense. Okay, let's apply this. We know Paula is a lifelong resident of State Alpha, so for jurisdictional purposes.
She's a citizen of State Alpha. Your citizenship for diversity is generally your domicile, where you reside and intend to remain indefinitely. Lifelong resident makes that pretty clear.
Okay, Paula, State Alpha citizen. Now, let's look at David's motion to dismiss. What happens depends entirely on where he's a citizen.
Absolutely. We need to figure out David's citizenship. Scenario 1. What if David is also a citizen of State Alpha?
Well, based on what you just said, Paula's from Alpha, David's from Alpha. That means no complete diversity.
Correct. Plaintiff and defendant share State Alpha citizenship. So unless there's some other basis for federal jurisdiction mentioned in Angela's hypo, which isn't indicated, the court must grant David's motion to dismiss.
Motion granted. Federal court can't hear it. Okay, scenario 2. What if David is a citizen of a different U.S. state, say, State Beta?
Now we're talking. Paula, Alpha, versus David, Beta. They're citizens of different states. Assuming Paula's claim meets that $75,000 amount in controversy threshold.
And complete diversity exists between them.
Exactly. So in that case, David's motion to dismiss should be denied. The case can likely stay in federal court, at least regarding the claim against him.
Okay. Denied. Makes sense.
What about if David isn't a U.S. citizen at all? Say he's a citizen of France.
That also works for diversity jurisdiction. The statute covers suits between a citizen of a U.S. state, Paula, and citizens or subjects of a foreign state, David from France.
So Paula from Alpha versus David from France, diversity exists.
Yes, assuming the amount in controversy is met. Again, David's motion should be denied in this scenario. Denied again. Okay, U.S. citizens from another state or foreign citizen both generally work. But Angela's notes had this specific point about lawful permanent residence, like someone with a green card. How does that fit in?
Yes, that's a really important nuance. It's a potential trap. The statute has a specific rule here. A lawful permanent resident alien is generally treated like a citizen of the state where they are domiciled.
So if David has a green card, but he actually lives in and considers State Alpha his permanent home, his domicile,
then for diversity purposes, he's treated as a citizen of State Alpha. So you'd have Paula, Alpha, versus David, treated as Alpha.
which means no complete diversity again.
Exactly. In that specific situation, a lawful permanent resident domiciled in the same state as the opposing party diversity is destroyed. David's motion should be granted.
Wow, okay, so domicile is key there, not just their immigration status on paper.
Very key. It's about their true home. So you see, the ruling on David's motion really hinges on pinning down his specific citizenship or domicile status.
Definitely need the facts there. And we keep mentioning it, but that $75,000, that's always in the background too.
Always. It's a separate requirement. The amount Paula claims in her complaint usually controls, unless, as Angela's notes might point out referencing case law, it's clear to a legal certainty that she cannot recover more than $75,000.
Okay, so for David, check citizenship domicile, check amount in controversy.
Got it.
Now, let's shift to Car Corp. They also filed a motion to dismiss. Corporations are treated differently for citizenship, aren't they?
They are. You don't just look at where the CEO lives. For diversity purposes, a corporation is considered a citizen of two places.
Two places. Okay, what are they?
First, the state where it's incorporated, where it filed its official paperwork to become a corporation.
Okay, state of incorporation. And second?
Second, the state where it has its principal place of business.
Principal place of business.
Yeah.
What does that usually mean? Like the headquarters?
Essentially, yes. The Supreme Court calls it the nerve center. It's where the corporation's high-level officers direct, control, and coordinate the corporation's activities. Think headquarters.
The nerve center. Okay,
Yeah.
So incorporation state and nerve center state. Let's apply this to CarCorp versus Paula from State Alpha. What if CarCorp is incorporated in Alpha and has its nerve center in Alpha?
Well, then CarCorp is a citizen of State Alpha on both counts. Paula is also a citizen of State Alpha.
The same situation as if David was an Alpha citizen. No complete diversity.
Correct. CarCorp's motion to dismiss should be granted in that scenario, assuming no other jurisdictional basis exists.
Granted. Okay. What if CarCorp is incorporated in Alpha, but its nerve center, its headquarters, is in State Beta?
Now it's different. Carcor is a citizen of both Alpha Incorporation and Beta, principal place of business. Paula is a citizen of Alpha.
So does the shared alpha citizenship kill diversity?
No, because complete diversity just means that no plaintiff shares citizenship with any defendant if that's the defendant's only citizenship. Here, Carcor is also a citizen of Beta. Since Paula Alpha is diverse from Carcorp Beta, diversity exists.
Oh, I see. As long as there's one non-overlapping state of citizenship for the corporation, it works?
Generally, yes, in this context against a single plaintiff. So Paula Alpha versus Carcorp Alpha and Beta, diversity holds. Motion denied, assuming the 75K is met.
Okay, denied. What about the flip? Incorporated in state beta, but the nerve center is in state alpha.
Same logic applies. Carcorp is a citizen of Beta Incorporation and Alpha Nerve Center.
Alpha.
Paula is from Alpha. Again, Paula Alpha is diverse from Carcorp based on its Beta citizenship.
So diversity still exists. Motion denied.
Correct. Motion denied, assuming amount in controversy is met.
Got it. It seems like as long as Carcorp isn't only an alpha citizen, Paula can likely keep them in federal court. What if Carcorp has no connection to alpha at all? Incorporated in beta, nerve center, and gamma.
Then it's even clearer. Paula, Alpha versus Carcorp, Beta, and Gamma. No shared citizenship at all. Complete diversity is definitely satisfied.
Motion denied for sure then, assuming the money is right.
Yes. Now, what if Carcorp is foreign, incorporated in Germany, Nerve Center in Germany?
Based on the David discussion, I'm guessing that works too. Paula, U.S. citizen versus Carcorp, foreign citizen.
Exactly. That falls under diversity jurisdiction suits between a citizen of a state and a foreign entity. Motion denied, assuming over 75K.
Denied. Okay. Angela's notes raise one more tricky point for corporations.
Mm-hmm.
What if it has both U.S. and foreign ties? Like, maybe incorporated in Delaware, but the nerve center is in Canada.
Yeah, that can happen, but the principle usually holds. Diversity jurisdiction covers suits between state citizens and foreign citizens, and even complex cases with diverse U.S. citizens and foreign parties.
So, Paula, alpha citizen versus Carcorp, Delaware citizen, and maybe Canadian entity. Diversity probably still exists.
It most likely would, yes. The foreign element typically supports diversity jurisdiction when a U.S. citizen is on the other side. Again, that 75K amount is always lurking.
Okay. So, bottom line for Carcorp, just like with David, it all comes down to the facts. Where was it incorporated? Where's that nerve center?
Precisely. You need those specific factual details to apply the rules correctly. And again, the amount in controversy must be met for the claim against Carcorp, too.
Right. Each claim needs to be assessed. Okay, this has been a great breakdown based on Angela's notes. What's the main takeaway for someone prepping for the bar?
The absolute key is understanding those two pillars of diversity jurisdiction. Complete diversity, every plaintiff diverse from every defendant, and an amount in controversy over $75,000.
And knowing how to determine citizenship for individuals, including that LPR rule, and for corporations with their dual citizenship.
Exactly. And recognizing that the court's ruling on these motions totally depends on the specific facts presented in the hypo. You need to spot the issue, state the rule, and apply it to the facts given.
Know the rules, apply the facts. Seems simple, but lots of nuances.
Definitely. That's why practice is key.
So here's something else to chew on as you study. We've focused entirely on diversity jurisdiction because that's what Angela's hypo pointed towards. But what if Paula's claim against, say, Carcorp wasn't just a typical state law claim, but alleged a violation of a specific federal statute?
Oh, well, that changes the game, potentially.
Right, because then we might not even need diversity jurisdiction. We could potentially get into federal court through federal question jurisdiction.
Exactly. If the claim itself arises under federal law, the citizenship of the parties might become irrelevant for getting the case into federal court.
Something else to keep in your back pocket. Okay, that's our deep dive for today. Good luck with the studies, Angela and everyone else hitting the books for the bar.
Okay, friends, here is the model answer to the situation with Paula. All right, so I'm reading this verbatim. I have asked the AI to generate a question and to generate the model answer. And then after I read this, I will have our AI buddies discuss why this is the answer. Okay, number one, David's motion to dismiss Paula's claims against him. The court should deny David's motion to dismiss Paula's claims against him. Explanation. Federal courts require subject matter jurisdiction commonly established through federal question jurisdiction. This is part of 28 U.S.C. section 1331, or diversity jurisdiction, Section 28 USC 1332. Paula's negligence claim against David is a state law tort, so federal question jurisdiction does not apply. Jurisdiction must be based on diversity. Diversity under 28 USC Section 1332 has two main requirements. A, complete diversity of citizenship. All plaintiffs must be citizens of different states from all defendants. B, amount in controversy. The amount in controversy must exceed $75,000 exclusive of interest and costs. Paula's citizenship. An individual's citizenship is their domicile. It defines their presence in a state with intent to remain there indefinitely. Citizenship is determined at the time the complaint is filed, which is June 1st, 2023. Paula, formerly a state Alpha resident, accepted a job in state Beta, signed a lease, moved belongings, and started working, and obtained a state Beta driver's license before filing suit. While she has some ties to state Alpha, her actions by June 1st, 2023 demonstrate physical presence in state Beta and an intent to make it her home, at least with no definite intent to leave at a specific time. Thus, Paula is a citizen of state Beta. David's citizenship. David is stated to be a citizen of state Alpha. Since Paula, who's in state Beta, is diverse from David, who's in state Alpha, complete diversity exists between them. The amount in controversy for claims against David. Paula is suing David for $30,000, which is property damage, plus $50,000 medical expenses, totaling $80,000. A single plaintiff can aggregate all claims against a single defendant to meet the amount in controversy requirement. $80,000 exceeds $75,000. Because both complete diversity and the amount in controversy requirements are met for Paula's claims against David, the court has subject matter jurisdiction over these specific claims. David's motion to dismiss claims against him should be denied. The jurisdictional status of claims against other parties, like CarCorp, does not strip jurisdiction over otherwise valid claims against David unless CarCorp's joinder itself destroyed complete diversity for the entire action, and CarCorp was an indispensable party, which is not the basis of David's motion regarding claims against him. 2. CarCorp's motion to dismiss Paula's claims against it. The court should grant CarCorp's motion to dismiss Paula's claims against it for lack of subject matter. Let me say that again. The court should grant CarCorp's motion to dismiss Paula's claim against it for lack of subject matter jurisdiction. Explanation. Paula's design defect claim against CarCorp is a state law tort claim seeking $70,000. Again, jurisdiction would need to be based on diversity. CarCorp citizenship. A corporation is a citizen of its state of incorporation and its principal place of business. And this is under 28 USC 1332, subsection C1. The PPB, or principal place of business, is its nerve center, where high-level officers direct control and coordinate its activities. And you can find this from the case of Hertz Corp versus Friend. CarCorp is incorporated in state Gamma. Its CEO and executive team, all making major corporate decisions, operate from state Alpha. Thus, state Alpha is CarCorp's principal place of business. CarCorp is a citizen of state Gamma and state Alpha. Complete diversity. Paula versus CarCorp. Paula is a citizen of state Beta. CarCorp is a citizen of state Gamma and state Alpha. Therefore, Paula is diverse from CarCorp. Amount in controversy for claim against Car Corp. Paula seeks $70,000 from Car Corp. This amount, standing alone, does not exceed $75,000. A plaintiff generally cannot aggregate amounts sought from different defendants to meet jurisdictional minimums unless the defendants are jointly liable for the same sum. The facts suggest separate grounds for liability. David for negligence in the accident, Car Corp for design defect contributing to injuries. Supplemental jurisdiction under 28 U.S.C. section 1367A allows courts to hear related claims. However, section 167B restricts supplemental jurisdiction in diversity-only cases over claims by plaintiffs against persons made under rules like FRCP 20, permissive joinder of parties, as Car Corp is here. If exercising such jurisdiction would be inconsistent with 1332, this includes failing to meet the amount in controversy requirement. The Supreme Court in ExxonMobil Corp. v. Alapata Services, Inc. clarified that while supplemental jurisdiction can cover claims of additional plaintiffs who don't meet the amount in controversy, parentheses, if one plaintiff does and diversity is maintained, it does not allow a plaintiff to sue a diverse defendant for an amount below the jurisdictional threshold simply because the plaintiff has a jurisdictionally sufficient claim against a different defendant. Each claim by a plaintiff against a specific defendant must generally satisfy the amount in controversy, or the claim against that defendant must be part of a single indivisible harm for which defendants are jointly liable for the full amount. Since Paula's $70,000 claim against Car Corp does not independently meet the amount in controversy requirement and supplemental jurisdiction does not cure this defect for the claim against the defendant, the court lacks subject matter jurisdiction over Paula's claim against Car Corp. All right, that was a lot. Why don't we hand it over to our AI buddies to really dissect this?